file and superseding information in this case. Upon filing the information, the defendant agrees to plead guilty to the charges contained in the information for a sentence for a determined period of 30 years in the Illinois Department of Corrections according to the following terms. Defendant shall plead guilty to involuntary manslaughter, a Class 2 felony with an extended sentencing range, and serve a period of 14 years in the Illinois Department of Corrections with mandatory supervised release period of 3 years. The defendant shall also plead guilty to aggravated battery of a child, a Class X felony, and serve a period of 11 years in the Illinois Department of Corrections. This sentence shall be served at 85% with mandatory supervised release period of 2 years. The defendant shall also plead guilty to concealment of a homicidal death, a Class 3 felony, and serve a period of 5 years in the Illinois Department of Corrections with a mandatory supervised release period of 1 year. The defendant agrees that each of these 3 counts shall be served consecutively to each other. In addition, the defendant shall participate in behavioral interviews for research purposes conducted by personnel from the Federal Bureau of Investigation's National Center for Analysis of Violent Crime, Behavioral Analysis Unit 3. The interviews will take place over the course of several days at a date, time, and place to be determined. The defendant shall also cooperate in the investigation into DCFS surrounding incident related to minor child AJ Freund, including but not limited to providing truthful interviews and truthful testimony at any trial or hearing. The defendant shall be considered a violent offender against youth and shall be required to register in accordance with the Child Murder and Violent Offender Against Youth Registration Act, and the defendant waives any and all pretrial motions as well as the right to confront any witnesses against him in this case.
And receives credit for time served.
And the defendant receives credit for time served, and Judge, that's the sum and substance of the negotiated plea in this matter.
All right. You're Mr. Andrew Freund?
Yes, Your Honor.
Mr. Freund, you're represented by your attorney, Mr. Sugden. Is that correct?
That's correct.
First of all, the state has filed a new information containing 3 counts. I'd ask Mr. Sugden if there is any objection to the state filing the information.
No, Judge, we've waived our right to an indictment.
Mr. Freund, your attorney's given me a document called Waiver of Preliminary Hearing or Indictment. Is that your signature on the document?
It is, Your Honor.
You understand that if the state files a new information in your case, you are entitled to a preliminary hearing or an indictment, and that by executing this waiver, you're giving up those rights. Is that what you want to do?
Yes, Your Honor.
The court will accept the new information. Now, Mr. Freund, you are charged with a 3-count information. First is aggravated battery of a child, normally a Class X felony. You could be sent to the penitentiary 6 to 30 years, 30, 60 years extended term, $25,000 fine, 3-year mandatory supervised release. You're also advised that the court may impose consecutive sentences, that you would be required to register under the Violent Offender Against Youth Act, and the sentence may be served at, was that 75 or 85%?
85, Judge.
85% under the Class X felony. You're also here on a charge of involuntary manslaughter, a Class 2 felony, normally 3 to 7 years, 7 to 14 years extended term, $25,000 fine, 2-year mandatory supervised release. You're also advised that the court may impose consecutive sentences. And that you may be sentenced to a term of not less than 3 nor more than 14 years on that charge. Also, you're here on count 3, a charge of concealment of homicidal death, Class 3 felony. Ordinarily, you can be sentenced to a period of 2 to 5 years in the penitentiary, 5 to 10 years extended term, $25,000 fine, 1-year mandatory supervised release. Sentences may be imposed consecutively, and the consecutive sentence may be required to protect the public. They may be imposed consecutively. Any other sentence enhancements that you're aware of, state?
Thank you, Judge. No.
Then, Mr. Freund, understanding the charges against you, the possible sentences, and the proposed negotiations in your case, do you wish to enter into a negotiated plea of guilty at this time?
Yes, Your Honor.
Did you have enough time to talk with your attorney about your negotiated plea, and are you satisfied with his services?
Yes, Your Honor.
Are you under any disability now either medical, mental, physical, or otherwise, that would prevent you from understanding the terms of your negotiated plea?
No, Your Honor.
If you are not a citizen of the United States, you are hereby advised that a conviction may carry consequences of deportation, exclusion from admission to the United States, or denial of naturalization under the laws of the United States. State, are you prepared to stipulate to the defendant's previous history of criminality?
Yes, Judge.
And do you wish to give that history of criminality, or would you take judicial notice of the pretrial bond report in this matter?
Judge, we'll take judicial notice of the pretrial bond report.
Are there any additions, subtractions, or deletions from the pretrial bond report that either one of you wish to make?
No.
No, Your Honor.
Defense, do you stipulate to the accuracy of the pretrial bond report?
Yes.
As a result, this court is cognizant of the defendant's past criminal history, and do both sides now wish to forego formal pre-sentence report before sentencing in this case? State?
Thank you, Judge, yes.
Defense?
Yes, Your Honor.
Mr. Freund, your attorney has provided me with several documents, one of which is entitled Waiver of Trial and Acknowledgement. Have you read this document? Do you understand it, agree with it, and did you sign it?
Yes, Your Honor.
You understand that by signing this document and submitting it, you're giving up the constitutional and other rights specified in this document, and you won't have a hearing or trial at all. Is that what you wish to do?
Yes, Your Honor.
Did anyone force you, threaten you, or promise you anything to get you to enter into this negotiated plea other than the terms of the negotiation itself that has been specified here today?
No, Your Honor.
How do you plead to the offense of aggravated battery to a child on or about March 4th, 2019 in McHenry County, Illinois? Guilty or not guilty?
Guilty.
How do you plead to the offense of involuntary manslaughter to a child on or about April 14th to April 15th, 2019 in McHenry County, Illinois? Guilty or not guilty?
Guilty.
How do you plead to the offense of concealment of a homicidal death on or about April 15th, between April 15th and April 24th, 2019 in McHenry County, Illinois? Guilty or not guilty?
Guilty.
At this time, the state may give us a factual basis concerning the defendant's plea.
Thank you, Judge. As part of the paperwork, I handed you up a written 15-page factual basis that I would ask to be spread of the record.
That will be spread of the record. Would you read that into the record at this time?
I can, Your Honor, yes.
Go ahead.
Now from the people of the state of Illinois, by and through Patrick D. Canale, State's Attorney for McHenry County, and present the following recital to the court of the evidence that the state would present at trial with respect to count 1, aggravated battery to child, count 2, involuntary manslaughter, and count 3, concealment of a homicidal death. Of the information filed on September 18, 2020 that supports the elements of the offense to which the defendant is pleading guilty. On April 18, 2019, at approximately 8 a.m., Crystal Lake Police Department responded to 94 Dole Avenue in Crystal Lake after receiving a call from defendant Andrew Freund that his son, Andrew Thomas Freund Jr., hereinafter referred to as AJ, born October 14, 2013, was missing. During the course of the investigation, police learned that AJ lived at 94 Dole Avenue in Crystal Lake, McHenry County, Illinois, with defendant Freund, defendant Cunningham, AJ's biological mother, and PF, AJ's biological brother, born December 30th, 2014. Upon arrival at the home, police observed the interior of the house to be in significant disorder, with clutter leaving very little floor space. In the basement, police had to move garbage bags in order to clear a path on which to walk. Upon moving the garbage bags, police observed cockroaches scattered. Outside of AJ's room, police observed a sliding chain lock capable of securing AJ from the outside. Inside AJ's room, police observed mouse droppings. Police further observed that the windows in AJ's room were secured shut with screws. Defendant Freund participated in 2 substantive interviews on April 18, 2019, wherein he denied any knowledge of AJ's whereabouts and involvement in AJ's disappearance. During the second substantive interview on April 18, 2019, defendant Freund described AJ as stubborn and headstrong. He stated further that AJ believed that he was the leader if we suggested that he needs to stop watching the movie and put away the toys. If that's not what he wants to do, he may not do it. In his mind, he's the leader and he doesn't have to listen. Defendant Freund stated further that AJ was subject to spankings and timeouts as a form of discipline. During the second substantive interview on April 18, 2019, defendant Freund and police engaged in the following exchanges. Police: sure. What would his behavior be to constitute that kind of a response? Defendant Freund, well, it would have to be pretty dramatic. Lying, I mean, lying in our house is like zero tolerance, you know, and that cannot happen, and that's not just one lie. It would have to be a multiplicity of lies or the same lie being told about the same incident. You know, and let's say his refusal to understand that we already know the answer, you know, we don't ask questions because we don't know the answer. Police, so you give him a couple chances. Defendant Freund, oh yeah, always, always, and I think this is what you're driving at, is after the second time, the third time, and it's still no, I didn't do it, or at that point, then the answer changes to something else on top of that. That's, you know, where the line issues become really out of control. The situation as parents, we can just say, oh well, it's okay. Police, right? Defendant Freund, you told a lie. Police, we can't accept that kind of behavior. Defendant Freund, no, you cannot. Police. So what happens? It goes back to discussion about severity, and I'm sure there's a whole panoply of other factors that come into play, and I mean, I suspect that it could be endless, but, you know, if the lying is just so egregious and so, you know, over the top, I'm trying to think of perhaps combined with disobedience, maybe something other than, you know, some other things that, you know, has been prescribed not to do. He might be put in his room for many hours because we've learned in the past that, you know, these theoretical 2-minute timeouts, they have no effect on him, none whatsoever. Police, I mean, so the police indicate, I mean, you're human. Defendant Freund, right, no. Police, level of patience, right? Defendant Freund, right. Have I spanked him hard because I was really upset with him? Yes, I have. Police, when was the last time that you had to use an extended timeout? Defendant Freund, maybe a couple weeks ago, I don't know. Last weekend, I mean, extended timeouts, they're different. I mean, sometimes if the behavior is really egregious, it might be an afternoon. Police, it's just an odd dynamic with all these different leadership roles going on in the House, and we'll get back to the timeout stuff. Defendant Freund, yeah, well, we will, and that's fine, and I'm glad you asked the question because it's really actually a very good question. And the simple answer is AJ has at times been the disruptive force in the House. I mean, if he's going to be between PF or AJ, it's going to be AJ that's the disruptive force. As a consequence, JoAnn and I tend to give PF a little bit more leeway. Police, I mean, has he ever thrown a fit when he's been in the room? Defendant Freund, no, he understands very clearly why he's there and why he gets lagged. There's no question that AJ understands. During the April 18, 2019 interview, Defendant Freund indicated that Defendant Cunningham was primarily responsible for caring for PF and AJ. Defendant Freund indicated further that he works as in-house counsel for a group of companies located in Riverside, Illinois that do mortgage, lending, and residential construction, among other things. Defendant indicated that he wakes up at 4:30 a.m., takes a 6:12 a.m. train to Crystal Lake to Ogilvie Transportation Center in Chicago. From Ogilvie, Defendant Freund walks to Union Station and takes a subsequent train to Riverside. Defendant Freund indicated that he generally returned home from work at around 9:15 p.m. Defendant Freund indicated further that at this time both AF and PF were generally still up, and he would assist with putting them to bed, brushing teeth, washing hands, you know, saying the prayers, stuff like that. During Defendant Cunningham's interview on April 18, 2019, she denied having any knowledge of AJ's whereabouts. She stated that she and Defendant Freund had been to AJ's bed the night before. When she woke him up the next morning, AJ was missing. During the course of the investigation, the FBI and the Crystal Lake Police were able to extract cell phone data from the Defendant Freund's iPhone. Pursuant to a search warrant, the iPhone data revealed that approximately 3 a.m. on April 15, 2019, a Google search was done for child CPR. During a subsequent interview on April 24, 2019, Defendant Freund revealed AJ's ultimate fate. During the second part of the interview, Defendant Freund indicated that AJ had died at some point on the evening of April 14, 2019, after Defendant Cunningham had engaged in some hitting and AJ had been placed in a cold shower. In explaining how AJ ended up in a cold shower and what happened, the Defendant Freund stated, Judge, at this point, it goes on for about a page with respect to the defendant's, with respect to a transcript of the defendant's interview. I would just ask that the factual basis reflect that so I don't have to read it out in court.
I understand that. I want the defendant, I think it's a critical stage in the proceeding, that he know what the factual basis is. So I know it's a lengthy factual basis, and I appreciate the state's attorney giving that factual basis. And I know it's a lot of reading.
Okay, I'll get to it.
I do believe that the defendant has a right to understand what the factual basis is, and therefore I'd ask you to put it into record that way.
You got it. Friend, it wasn't intentional. There were, in the past, JoAnn would hit him, and oftentimes I had interceded to stop that from happening, and I tried to convince JoAnn that that's not the way to go. And now he's 5, so she had to come up with the idea of putting him in like a cold shower as punishment. Friend, and I suspect that I can rationalize in a lot of different ways. Donahue, do you want to stop this and get your head together or your thoughts or whatever, friend? No, that's okay, that's okay. You know, part of it was that sometimes when JoAnn would get angry and there wasn't a whole lot that I could do to stop things, and a lot of times when I would try to, it just made it worse. Police, was he told that he couldn't come out of the shower? Friend, yes. Police, okay. Friend, yeah, it was his punishment. Police, okay. Friend, and you know, I acceded to it because the alternative was more physical beatings. Police, right. It's understandable, friend. Okay, but again, that doesn't justify, what I should have done is something entirely different. Police, we understand. Friend, okay, I didn't, and that is my responsibility. Friend, yeah, so she found this, like a couple pair of underwear under the closet door, and she asked him about it. Well, why it was there, and he wouldn't tell her, and then I think if I recall correctly, so that's when he started going in the shower. Police, what is saying when he's going in the shower, being sprayed? What's he saying? Defendant friend, he's saying, I'll tell you the truth. Okay, tell us, and then he wouldn't. Police, so more spraying? Defendant friend, well, more staying in the shower. Police, and then he call, and then I'll tell you the truth again. Defendant friend, yeah. And so go in, no truth, shower continues. Friend, yeah, while he was being questioned, she was like taking the spray nozzle thing and putting it like right in his face, sometimes loses balance and fall in the tub. I don't know, remember it being as bad as other nights where it was just pure, physical punishment hitting. Defendant indicated that he intervened between Defendant Cunningham and AJ and took AJ out of the shower. Defendant friend indicated further that after taking AJ out of the shower, he put him to bed. During Defendant Cunningham's psychological evaluation report dated January 24th, 2020, Defendant Cunningham described that night of AJ's death to the evaluator, Dr. Robert Meyer, saying that she just felt a lot of rage, that she lost control and was in an extreme rage. When asked where Defendant Fred was that night, Defendant Cunningham advised, I don't know where Drew was that night. Defendant Friend indicated that he was woken up by Defendant Cunningham at 3 a.m. on April 15, 2019, and was told by Defendant Cunningham that AJ was not breathing. After realizing that AJ was dead, Defendant Friend indicated that he told Defendant Cunningham he would handle it and placed AJ's remains in a large plastic tote in the basement. Specifically, Defendant Friend stated. Defendant Friend. So I attempted to resuscitate him Monday night, and I know we dressed him and tried to get him warm, but I don't obviously that didn't work. Defendant Friend. So anyway, I carry him downstairs and we left him downstairs until Wednesday night, April 17, 2019. Police, where downstairs? Friend, there's like a big plastic tub, I don't know what's in it. Christmas decorations or so, I don't remember what was in it. Just placed down on there. The boys weren't allowed down there, so there wasn't a risk that PF. Defendant Fred. All right. So I put in a couple of plastic bags and I put him in the trunk of my car and drove him out. Obviously, I will show you where that is. On April 24th, 2019, Defendant Friend led authorities to AJ's body, which was buried in a shallow grave in rural Woodstock, Illinois. A subsequent autopsy performed by Mark Wittick, forensic pathologist, revealed multiple blunt force injuries to the head, torso, and extremities, including A, severe swelling of head, soft tissues with multiple bruises and abrasions. B, severe swelling of the brain. C, multiple abrasions and contusions of torso and all four extremities. D, bilateral inhaled blood in the lungs. Pattern injuries, of small circular abrasions on the central forehead. These circular abrasions match the pattern of the detachable shower head spray face. If called to testify, Dr. Wittick would testify that AJ died of craniocerebral trauma head injuries due to multiple blunt force injuries to the head. If called to testify, Dr. Wittick would testify further that AJ's injuries were consistent with child abuse and not consistent with hypothermia or falling. At trial, the state would also present evidence that in the years and months prior to his death, AJ had previously been the victim of a number of prior incidents of child abuse, torment, and callous neglect at the hands of Defendant Cunningham. The following is a list of witnesses the state would call and a summary of their expected testimony. Janelle Vanette. Janelle Vanette lives at 105 Dole Avenue in Crystal Lake, Illinois. October 31st, 2017, Defendant Cunningham arrived with AJ at her house to trick or treat. Vanette observed that AJ had a substantial amount of medical tape wrapped over his head and torso. Vanette observed further that AJ's face was covered in Vaseline and that clumps of his hair were missing. Vanette inquired as to whether AJ was a mummy for Halloween. Defendant Cunningham indicated that he was not dressed as a mummy, rather those bandages were applied after AJ accidentally spilled boiling water all over himself. On a snowy winter night at around 10:30 p.m. in 2017 or 2018, Vanette was walking her dog in front of Defendant Cunningham and Defendant Friend's home. She observed PF to be in a running car in the driveway with the doors open and only wearing a diaper. She heard PF yelling, "Daddy, I'm cold." She heard Defendant Cunningham and Defendant Friend arguing inside the home. She then observed AJ after he jumped out from behind a pile of black plastic bags and yelled, "Boo." Vanette inquired of AJ what they were doing outside so late. He said they were going to a hotel if Mom and Dad don't kill each other. Defendant Cunningham then came out of the house and confronted Vanette. She told Vanette, "You better not fucking call the cops on us." When Burnett tried to engage defendant Cunningham responded, "Leave me the fuck alone." James Rossell. James Rossell lives at 105 Dole Avenue in Crystal Lake in proximity to defendant Freund and Cunningham. On Halloween of 2017, AJ and defendant Freund arrived at his home while trick-or-treating. He observed AJ to have a number of bandages on various parts of his body. Defendant Freund explained to Rossell that the injuries were caused by AJ having spilled boiling water on himself. Adam Lamberti. Lamberti has been employed at BCU Credit Union in Crystal Lake for the past several years. Defendant Freund and defendant Cunningham maintained deposit accounts and 2 auto loans at BCU from approximately the fall of 2016 to the spring of 2018. Defendant Cunningham would request to speak with Lamberti when conducting her affairs at BCU. On 3 occasions in the spring of 2018, Lamberti noticed significant bruising on AJ, who accompanied his mother on her visits to BCU. On the first occasion, Lamberti noticed that AJ had an extremely dark black eye and bruises on his neck and arms. Upon Lamberti inquiring as to the cause of these injuries, Cunningham stated that AJ had accidentally, quote, fallen down the stairs, end quote. On the second occasion, approximately 3 weeks after the first, Lamberti observed that AJ had a cut and black and blue bruises on his arm and face. Cunningham explained to Lamberti that AJ had entered their basement and hit himself with power tools. On the third occasion, Lamberti observed AJ to have bruising to his face. Cunningham did not offer an explanation as to the cause of these injuries. Scott Barfus. Scott Barfus is employed as a lawyer at Father and Son Home Improvement in Riverside. Prior to defendant Freund's arrest, he also worked at Father and Son's Home Improvement. Barfus and Freund had worked together for approximately 3 years and were the only 2 lawyers employed by the company. At the end of March or early April 2019, defendant Freund had brought AJ to work. Barfus observed AJ had significant bruising and cuts on his forehead and the side of his face. After inquiring as to the cause of these injuries, defendant Freund replied that AJ fell down the stairs. David Lewis and or other staff at Gottlieb Memorial Hospital. March 18, 2018, David Lewis was working as a social worker at Gottlieb Memorial Hospital in Melrose Park. On that date, defendant Cunningham was transported to the ER after being found asleep in her car with fresh track marks up and down her arm. Defendant Freund and AJ subsequently arrived at the hospital. Defendant Lewis observed bruising to AJ's face and forehead. Jessica Crabtree. Jessica Crabtree had been friends with defendant Cunningham for the past 5 years. In 2019, Crabtree observed AJ to have injuries to his face on 2 occasions. On the first occasion, defendant Cunningham claimed that AJ was burned by a pot of water. On the second occasion, defendant Cunningham stated that AJ had fallen down the stairs while sleepwalking. Officer Kimberly Shipaw and Dr. JoAnn Cunningham, medical doctor. On December 18, 2018, defendant Cunningham called the police to report that her Suboxone medications had been stolen by her paramour, Daniel Nowicki. Upon arrival at the 94 Dole residence, police observed the house to be, quote, disgusting, end quote. The ceiling was falling down, the floor was torn up, the children's bedroom smelled like feces, and there was dog urine on the floor. Police observed a large bruise on AJ's head toward the back. Defendant Freund indicated that the bruise was caused by the dog. AJ was subsequently taken to Northwestern Hospital in Woodstock and was examined by Dr. Channon. During the examination, Dr. Channon reported contusions to AJ's upper lip and right hip. During the course of the interview, AJ began by saying that the injuries were caused by a family dog. In private, AJ revealed to the doctor that a belt made the mark on his hip, but stated it was caused by someone not his family. AJ then stated that his mom did not, quote, mean to hurt him, end quote. AJ was released by DCFS from protective custody to defendant Freund. On December 19, 2019, defendant Freund was interviewed by a DCFS agent. Defendant Freund denied that defendant Cunningham was abusing or had a history of abusing AJ. Defendant Freund also denied that defendant Cunningham was using heroin. Defendant Freund stated that though he was working long hours during the week, he has not observed anything concerning when he is home. Officer Michael Maloney. Officer Maloney is employed at the Crystal Lake police officer. During the course of the investigation and through numerous subpoenas, Officer Maloney was able to acquire access to Ms. Cunningham's iPhone data, both on the phone itself and Ms. Cunningham's iCloud account. From the iCloud account, Officer Maloney located a video with a file date stamp of March 4, 2019 at 1:55 p.m. This video depicted defendant Cunningham recording AJ as he lay on a bare mattress in a crib located at 94 Dole Avenue residence. AJ appeared to have small white bandages covering areas on both of his forearms and a cloth bandage wrapped loosely around his waist. There were wounds and bruises on his arms and waist. AJ is also holding a large blue ice pack over his face, and when removed, revealed severely swollen eyes covered with large dark and red bruising. During the video, defendant Cunningham is berating AJ for soiling the mattress. During defendant Freund's April 24, 2019 interview, he stated that defendant Cunningham caused these injuries to AJ. With regard to the March 4, 2019 video, defendant Freund stated during his interview on April 24, 2019, police. Okay, you remember that video though, defendant Freund? I mean, I remember that JoAnn has sent that to me like while I was at working something, probably. Police, those you mentioned earlier before your attorney arrived, so I want to make sure he knows too. That you saw that video that we showed you, and there are other videos like it that you had seen before, that you had received from JoAnn. She would send them to you, right? Is that what you said? Defendant Freund, yes, police. How long did that go on, that she would send you random videos? And I mean, I know you're not in her mind, Andrew, but you have guessed some degree during the course of this investigation. Do you know why she would do that? Defendant Freund, well, I mean, I can guess. Donahue, do you want to answer that question? Defendant Freund, well, I mean, it's a guess, okay? I mean, she can tell you more specifically, but my guess is that, she was looking for support. I think she enjoyed this. I mean, I know she didn't enjoy this. I don't think she enjoyed this. I mean, I know she didn't enjoy this. I think she was looking for some support from me in terms of, disciplining AJ. That, police, she wanted you to be a unified front. Defendant Freund, right, yes, exactly. So that's my guess. I mean, it wasn't like, haha, hey, Drew, here, look at this. It was more like, please, can you help me with this? This is how bad it's getting, Dad. That's my guess. Police, that video that's dated May 4th, how did he get those? Freund, May 4th, police. March 4th, sorry. How did he get those bruises and those injuries? If you remember from the video, he had one of his wrists and one of his other arms were wrapped, and then he had wrapping around his hips. Who did that dressing? Freund. JoAnn would have. Police. Who caused those injuries? Freund. JoAnn. Police. Do you remember her causing those injuries? Freund. Well, if I recall correctly, that would have happened during the day when I was at work. That's why she would be sending them to me, because I wasn't there. From the iPhone, Officer Maloney was also able to locate a video with a file date stamp of March 17, 2019 at 11:31 a.m. The video depicts Defendant Cunningham, Defendant Freund, PF, and AJ at St. Thomas the Apostle Church in Crystal Lake. AJ has significant bruising to his forehead. From the iPhone, Officer Maloney was able to locate a video with a file date stamp of March 27, 2019 at 8:22 p.m. This video depicted Defendant Cunningham cornering AJ in a bathroom at 94 Dole Avenue residence and confronting him, as it appears that AJ has said that he was going to get her in trouble with someone. AJ has visible cuts and bruising to his face and forehead. Defendant Freund begins profanely and in a menacing and aggressive tone interrogating AJ on who he is going to, quote, get her in trouble with, end quote.
Excuse me, not Defendant Freund, Cunningham.
Excuse me.
Freund wasn't brave.
Defendant Cunningham, excuse me, yes, that's a typo. Defendant Cunningham begins profanely and in a menacing...
Court notes a typo. Go ahead.
Thank you, Judge. In a menacing and aggressive tone interrogating AJ on who he was going to get her in trouble with. At one point, she tells him not to, quote, bullshit her, end quote, asking AJ if he thinks she is, quote, dumb and does not know the answers to the questions she is asking, end quote. She then grabs him by the throat and pushes him against the wall, insisting that he tell her who he is going to get her in trouble with until AJ chokes for air. After AJ says he loves his family, Defendant Cunningham responds, quote, bullshit, you don't show it, end quote. Defendant Cunningham then positions her face inches from AJ's, asking him if she, PF, or Defendant Freund, quote, do evil in this house, end quote, to which AJ responds, quote, no, just me, end quote. She then asks AJ why he wanted bad things to happen to PF. Answering her own question, she says, quote, is it because he, PF, sees through your fake-ass bullshit, end quote. After AJ says, quote, he just wants to be alone and not have anyone around him, end quote, Defendant Cunningham replies, quote, you are alone in your room all day, end quote. AJ responds saying, quote, I just don't want a family, end quote, to which Defendant Cunningham yells, quote, you don't have one, that's daddy included, end quote. She then says, quote, you have daddy all mixed up, end quote. She continues, you really think daddy would choose you over me and PF? She then says that Defendant Freund thinks AJ is a, quote, liar, end quote, and, quote, manipulator, end quote, and he knows your plans, quote, knows your plans, end quote. Defendant Cunningham then tells AJ that he, quote, thinks he can do whatever the hell he wants, end quote. Thereafter, she puts her mouth to AJ's ear and screams, quote, it doesn't matter, none of it's going to happen, AJ living alone with his father, ever, end quote. At the end of the video, Defendant Cunningham indicates that she's going to send the video to Defendant Freund. Judge, that's a complete recitation of the factual basis.
Thank you, Mr. State's Attorney. Defense, do you stipulate that the information contained in the factual basis for defendant's plea of guilty would be the information presented at trial in this matter?
Yes, Judge.
Mr. Freund, is there now anything you wish to say before I accept your plea of guilty and pass sentence in your case?
Nothing at this time, Your Honor.
This court has considered all relevant sentencing factors and options, and the court will accept the terms of the negotiation presented to the court from the parties. The court makes the applicable findings of fact as specified in the sentencing orders. The court will sentence the defendant first on the charge of aggravated battery to a child. The court will sentence the defendant to a period of 11 years, 0 months in the Illinois Department of Corrections, with a period of 3 years mandatory supervised release. I believe that aggravated battery to a child will be served at 85% under the Truth in Sentencing Act. In regard to count 2, involuntary manslaughter, the court will sentence the defendant to 14 years, 0 months, with 2 years mandatory supervised release on that charge. And pursuant to Truth in Sentencing, I believe that charge will be served at a minimum of 50%. In regard to count 3, concealment of a homicidal death, the court will sentence the defendant to a period of 5 years, 0 months, 1 year mandatory supervised release. These charges will be consecutive, commencing with count 1, then count 2, then count 3. 1 year mandatory supervised release on the concealment of a homicidal death, and I believe that charge will be served at a minimum of 50%. Also, the defendant will be required to register under the Violent Offender Against Youth Registration Act. The court believes that these sentences should be consecutive for the protection of the public. The court notes that the defendant shall be considered a violent offender against youth, shall be required to register pursuant to that act, and the defendant shall cooperate in the DCFS investigation, and he agrees to be interviewed by the FBI's BAV unit as specified in the negotiated plea, sum and substance mentioned by the state.
Judge, in addition, he gets credit for time served from date of arrest. He's been in custody ever since.
I haven't forgotten that, Mr. Sugden. And he will be given credit for the time in custody from, I believe, 4/26/2019 until the date he is received by the Illinois Department of Corrections.
Thank you.
Do we have Mr. Freund's financials up? Mr. Freund, on the screen in front of you, you will see your financial obligations in regards to this case. You will also be given a hard copy of those financial obligations. And therefore, the court finds it is complied with Supreme Court Rule 452. Mr. Freund, you have a right to appeal. Prior to taking an appeal, you must file in the trial court within 30 days of the date of which the sentence is imposed a written motion asking to have the judgment vacated and for leave to withdraw your plea of guilty, setting forth the grounds for your motion. If your motion is allowed, your plea of guilty sentence and judgment may be vacated, and a trial date would be set on the charges to which your plea of guilty was made. Upon the request of the state, any charges that may have been dismissed as part of a plea agreement may be reinstated and set for trial. If your motion is denied, you have 30 days from the denial of the motion to file a written notice of appeal with the clerk of the court, or to request that this court direct the clerk to prepare and file with the trial court a written notice of appeal. If you are indigent, a copy of the transcript of these proceedings at the time of your plea of guilty and sentence will be provided without cost to you. and counsel will be appointed to assist you in the preparation of any motion or appeal. In any appeal taken from a judgment on your plea of guilty, any issue or claim of error not raised in a motion to vacate the judgment and withdraw your plea of guilty shall be deemed waived by the appellate court. Do you understand your rights to appeal?
I do.
You are remanded to the Illinois Department of Corrections, first to the McHenry County Sheriff's Department for transport to the Illinois Department of Corrections. This concludes the case.
Thank you. Thank you, counsel.